My name is Chris O'Connor and I'm the Director of O'Connor, Ruddy and Garrett Solicitors. Today, this video is to discuss superannuation in the context of estate planning and particularly blended families. There can be unintended consequences which arise where the control of a self-managed super fund is not carefully considered as part of a comprehensive estate plan. It is a common misconception that people think that superannuation entitlements at death automatically form part of someone's estate and they are distributed in accordance with the terms of your will. This is not the case. Superannuation is a separate asset and is dealt with independently of the terms of your will. Normally, superannuation funds will send you forms, normally called a death benefit nomination form or similar, where you nominate a beneficiary of your superannuation death benefit entitlement. This form has the same effect as a will, but only for your superannuation. That is, it binds the trustees of your superannuation fund to pay the death benefit to whom you nominate. Depending on the superannuation fund, most death benefit nomination forms are only valid for 3 years, and after such time they will lapse. When a death benefit nomination is either not made, although the beneficiary you have nominated is not valid, or it has expired, then the trustee of the superannuation fund has discretion as to where they pay the death benefit. It is normally at this point when a dispute arises over someone's superannuation death benefit entitlement. In order to be eligible to claim superannuation, you have to be what they call a dependent person. This includes a spouse, whether legally or in a de facto relationship, whether same or opposite sex, a child, including adopted child, ex-nuptial child, or a stepchild, a person who had an interdependent relationship with the deceased member, any person who is financially dependent, whether wholly or partly on the deceased member. In each case, the meaning of dependent will depend on the governing rules of the relevant fund. The fund rules do not have to permit distribution of the death benefit to all possible types of dependents under superannuation law, and they also specify a certain level of dependency in order to be a person who's eligible. There has been a significant increase in superannuation disputes given the complexities in people's family arrangements, and this issue is highlighted more so with blended families. There has been cases that have gone before the court where a child has been the sole trustee of a self-managed super fund after their parent has passed away, and they have distributed the death benefit from the self-managed super fund to themselves personally and not distributed any benefit to the siblings or step-siblings. In some of these cases, the court held the decision to pay themselves was completely legal. This just illustrates that there was a lack of considered estate planning when looking at their succession issues of self-managed super funds or any superannuation funds for that matter. In order to ensure your superannuation is dealt with in accordance with your wishes and your overall estate plan, please contact our office for a free initial consultation. Thank you.